Avoiding litigation is the topic we're going to discuss now, and frankly, that can be a big issue because of the tremendous amount of money involved once you get involved in litigation. It's not only expensive from the standpoint of what you're paying the attorneys, and it not only takes a long time in terms of years, many times in the case of business cases, because it's a low priority in the court system, but also your time is tied up and your emotionalism is tied up. So we're going to talk about things that probably can be done to reduce your probability involved in litigation. Again, prevention to me is better than going after the fact. And so let's get started on it. Documentation is the key. Everything should be documented. Every meeting you have, every phone call with your clients. If it's you're in a business where you're buying unique things rather than just things from Costco or Staples, you might want to document those meetings and sessions also. And before you write up the things, always think it out. And one of the problems I see with people with emails, it looks like they don't think out what they're saying. They just type away because we're so used to doing that. Same way with messaging. We're learning some bad habits through emails and messaging of not thinking out and making ourselves clear. And certainly you have to do that when you do the documentation meeting. Because it's terrible when I have people come in and say, well, I wrote this 3 years ago and I have no idea what I wrote. Well, that doesn't help. You have to be clear enough writing so you understand what you wrote down. And the documentation can be your best defense or your biggest mistake. And the biggest mistake are usually emails and messages in general. And I think you've all probably read in the newspapers, especially if you get the Bloomberg Business News or Wall Street Journal, Investors Daily, etc., of the situations where people got in trouble because of the emails they wrote. And remember, all your records are subject to discovery unless they're client privilege with the attorney, and you can't have client privilege until you get the relationship with the attorney on the particular issue. And they will tell you what you can keep private, but other than that, your books are open for everybody. Your files, your emails, your messages are open for anybody in a lawsuit. Contact your attorney before, not after. Attorney must be provided all the documentation material possibly related to the issue. You can't hold it back. You can't pull a Hillary Clinton and just get part of it. You can't destroy it because, unlike Hillary, you're going to go to jail if you destroy information that's you're not supposed to, or could go to jail, I should say. Attorney will tell you what is confidential client attorney legally privileged data that you don't have to provide to other people, but that's going to be, again, limited, and it's based on timing, also a big factor. I can say there's some education you should have as a business person. One is on labor relations, what you can and cannot do with your employees, what type of IT protection you can have and how you protect your IT. Protecting your trademarks and your copyright material is very important because many times that's what's your biggest contact with clients and potential clients. And then there might be some specialized courses your attorney recommends. It might be in the education might be in writing style. I hated to say that, but I've had people say they can't read understand what they wrote 3 years ago. That's telling me that they got to look on at how their writing style is so that they can learn what they said, they can be able to understand what they said 3 years ago. Alternatives to litigation. First of all, negotiated settlements are usually the best bet, and it's relatively inexpensive, and you retain complete control. And for business people, control is very important, and it certainly must be for you to protect your business. It only works if both sides want to settle the issue, and if one party doesn't want to settle, there's no sense having negotiations because you're not going to be able to settle reasonably. And I think that's one thing politicians forget, especially in international relations. And usually, if it can't be settled at the working level, then the management or the attorney will lead the negotiations after the lower levels to do it. Now, if you're starting your own business, you will be the negotiator or you'll have your attorney. I really recommend you do it. Attorneys like to argue and come up with and not settle, and they're like engineers. Engineer, if you give a design, they'll spend the rest of their career on that design because they can always find a way to improve it. And attorneys are the same thing in a negotiation. They can always find another way to get accomplished. And of course, as a business person, you got to cut bait. You got to do it now. So I think your company, you as an individual, probably can do a better job in most cases than your attorney. You can have the attorney on your team with you, but you should lead the negotiations. Mediation is a tool where a third party brings the two sides together by acting as an intermediary. Many times it's used when there's bad feelings between the parties. For example, one of the parties is caught lying, or one of the parties says something crude at a meeting, or one of the parties talked down to the other. And I was in a negotiation many years ago where there was first time I think we had a woman involved in a negotiation, and someone said, well, she's only a woman. Well, I don't know if he said it intentionally or sarcastically, but the negotiation stopped right there. So that's when mediation might come in. The good news is in a mediation, you always control, you decide whether you're going to settle or not. The mediator's job is to try and get you and the other party in an area of overlap so that you can reach agreement. Let's face it, when I'm negotiating, I never give you my best position up front, neither does the other side. So we don't know if we overlap unless we get across settlement. And I think mediators are good at finding out what your best sides are, what you're willing to settle, and then be able to come and overlap. I did a similar type once with another individual. We sat in a negotiation, and it was dealing with the licensing agreement. And we had negotiated for about 2 weeks, and we got to the point where we were significantly far apart. And make a long story short, he was taking me to the airport. And as we were sitting in the airport, we were watching Nixon give his speech that he was not a crook. And we were kind of joking about it at the time. And then we had a couple of more drinks, and then one of us said, I'm sure we can meet each other halfway. And then one of us, and I don't even remember who because we were pretty well loaded, said, okay, what we'll do is we'll give the bartender our best positions. You give your best position, I'll give mine on a piece of paper. If the bartender sees they overlap, he will tell us what that overlap is. If they don't overlap, he'll throw away the papers. Well, sure enough, we give him the papers our best position, and we overlapped quite a bit, actually. And so we split it down the middle. And, of course, we wrote it up right away because we both knew we had too much to drink. But that is sort of like a mediation where the bartender played a minor role, but a very important role because he decided whether or not that negotiation was going to get settled. Alternative is continued. Arbitrations can be very formal and similar to court actions, or it can be very simple. Key is a third party, usually 1 to 5 persons, is deciding the outcome rather. Formals tend to be very procedural, very expensive, very time-consuming. It's very much like a court, except instead of have a court of 1 judge or an appeals court of 5 or 7 judges, the arbitration board could be 3 to 10 people on it, depending on the type of system you use. Informal is what I prefer by far. It tends to be completed in a very short time period, very inexpensive. And the example I've done, and I'll give you a true example, I was doing some work in the aerospace industry, and we had a difference of opinion with our supplier as to whether or not the supplier had completed the testing in the way they were supposed to. And it was a basic issue in physics that was involved, and our physicists claimed one thing, theirs another. So what we agreed is we would go to Caltech, and there's a physicist there at Caltech who was an expert in the field, and we hired him, and we'll just say for $1,000 an hour. He would listen to us, and we'd listen to the other side. At the end, he would go and make his decision. So we met at, I think, 5 o'clock at night, and we were there with him till 7. He told us to go out for supper. We came back at 9. At 9 o'clock, he gave his decision. Now, that decision is binding. In fact, you could go to court if the other party didn't comply with it. And it cost us $2,000 or $3,000, and it was over within 4 or 5 hours. Had we gone a formal route through the American Arbitration Board, we probably would have had 6 months and spent $30,000. So I like the informal. And arbitration, especially good when it's something other than legal law issues. It's issues such as a client and your disagreement on something, which is probably related to people differences or differences of philosophy or difference in theory as opposed to a legal issue, because then we can pull in people and experts in the field. For example, if it's got to do with what is risk management, your psychologist. If it's a case of whether or not you were meeting your due diligence, we could bring in a financial advisor, investment advisor, etc. So usually a college professor or someone well known in the industry. Although arbitration method doesn't use precedents or law, decisions are enforceable throughout the world, and that's what makes it so nice. Mediation, you can't force anybody to do it, and negotiations, you can't force people, but an arbitration will carry it out. And of course, that means you give up control, and it's risky because, quite honestly, the arbitrator doesn't go by any special set of rules. They go by what they think is right in the situation. So in a law case, you'll have a winner and a loser. In an arbitration case, it may be a little bit of win and a little bit of loss for each parties. When I got out of law school, I did some arbitration, and my goal was I wanted to have an unhappy defendant and an unhappy plaintiff, because if they were both unhappy, that meant I did my job. And too often was, unfortunately, splitting the difference between the two, which is perfect legal for arbitrations, but you could not do that in the law case. In the law case, it's winner or loser. Some erroneous ideas about litigation. Unfortunately, most professionals believe any litigation is covered by insurance. This is not true. The types of policies determine what type of litigation is covered, and I think there's certain things to remember, and these are 4 of them. 1, insurance companies want to save cost and may settle against your best interest, and that's happened to me twice, where I was right, but they said, Lee, it's going to cost us $50,000 to go to court. We can settle for $20,000. It's a great deal. Of course, my insurance rates went up. Insurance companies will increase premiums or drop you after a lawsuit, even if you win. And that's another reason not to go after the insurance companies, because the increases are substantial in the premiums. And it's even worse if you lose, because if you drop by an insurance company, it's hard to get another insurance company to pick you up. Not everything can be covered by insurance. Reckless acts and intentional actions are generally excluded. And again, you're not only fighting the other party, you're fighting your insurance company. And people actually have had to hire lawyers to get coverage from their insurance company, and that becomes extremely expensive, because once you get the insurance covered, then they'll proceed. But if it's determined they aren't liable, then you're subject for the second lawsuit, which is with the other party. And there's always deductions and caps on insurance, and that you got to take into account. The relationship with attorneys, picking the right attorney is the goal. Textbook covers how to obtain recommendation for choosing a business attorney for your business. In addition, attorneys should have similar ideas and ethics as the company owner possesses, and that's very important. If you don't communicate, that's not going to be a good relationship. It's like being married. If you have different ethics standards than your spouse, and you have different ideas of what you want to do, you want to go fishing all the time and she wants you to work all the time, or vice versa, you want her to stay home and she wants to work, you're going to have problems. The same way with members of your professional organization are a good reference source for attorneys. They can tell you who they've had success with and who they haven't. If you have a CPA that you have complete confidence in their judgment, they can tell you of affiliated companies, attorneys rather, because most CPAs have relationships that develop with attorneys. And what I like to say is financial planners also have relationships with attorneys. And always check the attorney in the Martin Hubbell Law Dictionary before hiring the attorney. They can go online or actually go to the library, either one, to find out how they rate the attorney. It's sort of like if you go to the California State Board to check on a medical doctor, you get a lot of information, not only where they go to school and their specialty and what languages they speak, but what type of internships they serve and any lawsuits, etc. How not to pick the attorney. One, adds in major ads in telephone books. Need I say more? That's good for drunk driving or something, but not for what we want in a business attorney. The attorney who doesn't know your business field has businesses that make things have differences than those providing services. In other words, many business attorneys deal with manufacturers. Those are not the problems you have. You have services. And again, best if you get financial service attorney. Relatives are usually thinking of your best interest, but at the same time, they may not know what the attorney knows about the financial community. So when your relatives are recommending, they're recommending, again, based on what they do, not on the activities you do. Hiring attorneys, there's statutory standard hourly fees. There's flat fees depending on the type of service. There's contingency fees and retainers. Sort of sounds like financial planners, doesn't it? Always be sure there's a cap on the hours authorized, because lawyers can go crazy if there isn't. Understand the time increments for billing, for example, 6-minute billings, 3-minute billings, 15-minute billings. Lawyers have been known to be able to get 28 billable hours out of a day, and let's begin on the minute rule. You have 3 phone calls, and that means 3 18 minutes or 3 20-minute sessions, even though they may be on the phone call in only a minute. Always document meetings, phone calls, etc. with your attorney, so that you have your version in case a dispute comes up. Because sometimes attorneys make a big mistake on how they bill, and it's funny, it's always billed higher, not lower.